when I say change in a pending case with respect to my experience at Civil Appellate, what I mean is there's an appeal pending the day I come in the door.
Sure.
I reach a judgment that, gee, this isn't the position I would have taken, and I go to the appellate court and say, basically, never mind.
Right.
That seems to me analogous to what we have here. It's different from the case where a prior administration takes a position in a trial court, loses, and then the new administration has to make a decision whether or not to take an appeal.
Well, you're
I think a
saying-
new administration.
On the other hand, wouldn't you also say that in a default judgment, there is no, at that point, there is really no investigation, no discovery, no reexamination of facts that might have gone at that point? And wouldn't at that point, wouldn't you say that that's a slightly different situation than a fully litigated and cooked appeal that you're talking about?
Sure, but to me, the default nature of this case cuts even more strongly against changing course, because the government, I assume, did what every ethical lawyer plaintiff side has to do, which is establish a factual basis for the allegations made in the complaint when they made them, and nothing would have happened. There's no action-forcing event like adversary litigation to have the government reassess that position.
And you find that more egregious than, say, an expenditure of millions of dollars of government discovery and time on a case and then abruptly dropping it?
I'm not saying it's, I'm saying it's unusual. More egregious. They're different situations.
Sure.
In your hypothetical case, the concern would be, on the one hand, it might be a worse case because the government has invested a lot more resources. On the other hand, it might be a less bad case because in the course of adversary testing, the government's initial position might have been eroded with further factual development. So it just strikes me that there are different considerations in the two kinds of cases.
Well, I'm going to go on, we'll follow up on that.
Okay.
Okay, Commissioner Melendez.
Yes, thank you, Mr. Justice. Just one question. What's your opinion as far as there were 4 parts to this, that was...
4 defendants.
4 defendants, and only one was basically upheld, or...
One was pursued to
The
judgment.
person, is that because, your opinion is because there was a weapon used, the nightstick?
I don't know what the reasoning of DOJ was. That's the most plausible explanation. To me, it is not a very convincing ground for distinguishing between the 2 defendants who were on the scene.
So, but if there was not a weapon used, then it would seem that all 4 would have been the same situation, since there were 2, basically, that were 2 people that were in front of the polling place. So I can't differentiate between those 2 people as far as one having the weapon, the nightstick, and the other not. So it just seemed to most ordinary people that if it wasn't for the nightstick, everybody would have been basically dismissed.
That's probably right if you're asking me for
Just your
DOJ. I mean, my opinion is that the nightstick shouldn't make a difference in the treatment of the defendants for 2 reasons. One, the sum total of the acts of the 2 defendants minus the nightstick still would have amounted to an actionable case of intimidation. That's my first point. And my second point is that the 2 defendants at the scene were acting in concert together, so it is perfectly fair to attribute the acts of the one to the other.
no.
I know, but I passed.
Yeah, she can wait her turn. I told Vice Chair Thomstrom that she would go after Commissioner Melendez. There is no harm, so Vice Chair
There
Thomstrom.
is, but I'll yield.
Thank you very much, Vice Chair Bertram.
And I thank you also. By the way, a good pal of mine who works with closely on voting rights issues is at Jones Day, and somebody I've been recently very much in touch with over the case, Mike Carvin. So,
Pal of mine too.
yeah, I'm sure. Look, two things. One, I focused here, I don't know, have you been here all morning?
Yes.
Yeah. Okay, I focused here somewhat on the question of the legal definition of 11B, in part because I arrived at the commission just in time for the 2001 hearings in Florida on the question of black disfranchisement in Florida in the 2000 elections. And there were many charges of voter intimidation that were floated at the time that were, contested. I mean, there were differing views on whether it amounted to vote, what happened, a police car parked at a certain spot, not far from a polling place and so forth, whether it amounted to voter intimidation. And there's nothing unique about Florida. I mean, this conversation occurs repeatedly across the country because there's this huge spectrum of events that one can label voter intimidation or not. And so I am a bit troubled by the absence of a tight legal definition rather than a common sense one here, and I wondered if you had any thoughts. And the other question I have, again, do you have any thoughts? This sparse record of the enforcement of 11B has meant it is a most minor provision of the Voting Rights Act. And I've written 2 books on the statute, and I haven't mentioned 11B in either one of them because it's played such a small role and under Democratic and Republican administrations. I mean, one case before the Bush administration, 2 during the Bush years. Got any thoughts on that? So 2 questions,
Sure.
got any thoughts
I'll
on?
try my best. On the question of standards, the case law is sparse, but it is not entirely without guidance. There are cases that say the provision should be construed broadly rather than narrowly. There are cases that say you don't need a subjective intent on the part of the perpetrator. There are cases that say, consistent with that, you measure intimidation by the response of a reasonable voter or poll watcher. And there is a general legal principle that if you have a somewhat open-ended standard, you don't necessarily need a precedent on all fours with the facts of your case in order to figure out whether the standard applies. Now, I have no doubt that there are many debatable cases of whether something would or wouldn't constitute voter intimidation, and I have no doubt that in a close and debatable case, there could be a proper exercise of enforcement discretion to say, it's a close case, we haven't enforced this statute very much, there's kind of a rule of lenity principle even in a civil injunction context. That would be a responsible decision. This, I have to say, does not strike me as a close case for all of the reasons that you heard before.